And our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us each and every Thursday. She offers her legal expertise by providing some general advice on the latest hot topics. Of course, having experience that spans more than a quarter of a century, Despina, in the area of property and commercial law. She joins us now. Morning to you, Despina.
Oh, good morning, Wayne. Good morning, Book.
How do you
Good morning.
How do you get to a quarter of a century when you're only 39?
Nice, Wayne. That's a very nice comment to make. Yes, I am 39.
So this morning we are talking retail, something we haven't spoken about in a while. So there's a few sticky situations, I guess I can say, are unfolding on the Gold Coast in particular at the moment, Despina. So what's going wrong? What is happening?
I think this was sparked by me reading this article in the paper recently about a particular lawsuit that's happening in the Supreme Court at the moment, apparently, and it's relating to Star Coffee Company at Harbourtown. You might have read that article recently. Yeah, so this particular tenant is suing the landlord, supposedly around certain representations. They say they were misrepresentations concerning the refurbishment that occurred over the last few years at Harbourtown and how it has supposedly affected their profitability in relation to their business. So I thought when I read this article, it was important to perhaps mention it within the context of what people really need to know and what's important about retail shop leases. So I don't know too much about this case specifically, but what I can do this morning is comment on retail shop leases and provide some tips and general guidance for tenants and what they really need to know when they actually enter into a retail shop lease.
And I think this is important because as the economy opens up yet again, of course, there are plenty of, vacant shops around at the moment. And I guess things will change as the economy starts to grow yet again. We'll see people taking on retail leases, but also buying existing retail shops as well. So this is something that will affect lots of people in the near future, Despina.
Well, that's right. I mean, the Gold Coast is full of retail shop premises, and we have to be very clear that we're only talking about retail shop premises and retail shop leases. This does not affect or refer to commercial leasing, which is quite different. And I do say that quite clearly because in Queensland and similar in other states, we have what's called the Retail Shop Leases Act. And the Retail Shop Leases Act that's been around for many, many years governs what happens in retail shop leases and retail shop premises. So it's really important to make that distinction. And this particular article that related to the Star Coffee Company at Harbourtown is and would be a retail shop lease because it's within a retail shopping centre. And I won't get into too much detail about the definition of what a retail shop lease is because it's not black and white, and there's a few different types of or a few different definitions you have to go through to determine if your premises are in fact a retail shop. But suffice to say that let's go through some of the things I want to talk about because definitely at Harbourtown, most if not all of those premises are in fact retail shop lease premises. So when I read this article, it was talking about representations that were supposedly made by the agent at the time that the tenant renewed their lease or took on a new lease. And that happens a lot, doesn't it? So you might have taken on a new lease, or you might have had your original lease that you negotiated 3 or 4 years ago, your term is up and you're renewing that existing lease. So same premises, perhaps the same landlord, but you are renewing your lease, so it's continuing. So what's really critical for tenants to understand in a retail shop lease is that before you actually sign that lease, before you actually go through that process, you will be going through a negotiation phase. And perhaps that is when you're initially dealing with the landlord's agent. And that is perhaps when the landlord's agent might mention things to you that are being offered. For example, they might offer a fit-out contribution. They might offer a rent-free period. They might say to you, well, this will be a gross lease. Which means you don't pay outgoings on top of the rent. You only pay for your usage costs like water consumption, electricity, phone, etc. So all these things that the agent might tell you as a tenant are very, very important because you take that information and then you decide, well, this sounds pretty good. I like the sound of these premises and this lease that's being offered to me. Then I'll go to the next stage, right? Which is when you might engage a lawyer and you start incurring costs. So all of the things that the agent has told you, you want to take a note of. But what's really critical here, which came to me when I read this article, and it occurred to me that I should probably mention this to listeners, is this, that when you enter into a retail shop lease, you have to complete a document called a disclosure statement. So you as the tenant have to complete one, and the landlord has to give you a disclosure statement. So in your own disclosure statement that you have to complete, and there's things such as who you are, the name of your company or business, whether you've owned other retail premises, and there's another section in the disclosure statement for you to complete, and this is the really critical part, and it talks about you detailing any statements or representations that were made to you by the landlord. So if you have been given representations or other statements as part of the lease offer, you need to put that in this disclosure statement, because if you end up in a dispute later about what was said at the time, then you can produce this to the court.
Mm-hmm.
So it sounds like you, from what you're saying, you need to keep pretty good notes whenever you're dealing with the agents or perhaps the landlord themselves. You need to write all this stuff down.
You do, but and you can go further. So often agents will send you an email detailing, well, here's a lease offer. And you might then reply and say yes, no, and there'll be an email trail.
Mm-hmm.
So, for example, in this section in the disclosure statement, it's only a 2-page document, but it's a very important document that has to be completed correctly by you. So if you want to detail statements and representations made, it's only a small section in the actual document to complete. It's not a very big section. So what I say to clients and I recommend is, if there's been an email trail with representations, or if there's not enough room to detail what you might have been told verbally, then you attach a schedule. So you say, see attached schedule, and you could even attach, for example, the email trail between you and the agent. So, and that would be a very clever way of doing it, for example. So you could say, see attached email trail between myself and the agent, and that might have gone on for, say, 1 or 2 days, and there's a back and forth response. And that can clearly, so if you ended up in court, that could clearly show to a judge, well, I can see the email trail where something was offered and then it was accepted, or some parts were rejected. And there's this back and forth email trail and communications, which essentially creates an agreement, an offer made and an acceptance.
Yeah.
And those are the statements and representations that I'm talking about at the very beginning that are made to you as a tenant that are critical. And you need to put it in this disclosure statement before you sign a lease, not after, but before you sign that lease.
Mm-hmm. Okay, so basically if a lot of communication is done verbally and you haven't put it into writing, you could be in big trouble.
Well, because some people might say, oh, okay, so why would I need to do this? Because the lease should document all of this. Yes, that might be correct, but sometimes it doesn't. Sometimes the lease doesn't accurately reflect that, and your lawyer should pick up on those things. But there might be other things that the agent said to you verbally that aren't necessarily or normally documented in a lease. And that is why it is critical to put it in this disclosure statement. For example, in this article, it talked about, if it's correct, it talked about representations made to this tenant about foot traffic and about how there were supposed to be additional car spaces and how there was not supposed to be additional food eateries that might have affected their business. So that is information you normally don't see in a lease.
Sure.
So those statements and representations should be put in a disclosure statement, you see, in those particular examples. And that would be very useful down the track if there's a dispute.
Sure. And where do we find these really important disclosure statements?
So there's a particular website, Department of Justice and Attorney General. Mm-hmm. And if you go on that website, and there are numerous forms, but if you just Google retail shop lease forms, even by doing that on Google, you will find them. But if you have a lawyer right at the beginning who understands retail shop leasing, then they should know this already. So it's very important to get representation early and to make sure you get that proper advice.
Definitely. Coming up next, we'll be discussing selling a retail shop. Who is liable if a business folds, the new owner or the old? More on Talking Law just after this. You're listening to Radio 97.